Happy Friday, everybody.
Happy Friday.
Welcome to Facebook Live. We actually have a newcomer to the show. This is Desiree, and I'm going to let Desiree tell you a little bit about what she does with the law firm.
Hello, everybody. My name is Desiree, and I'm a personal injury paralegal here at the Brandy Austin Law Firm. I pretty much work on cases after suit has been filed, and I also handle cases before the suit has been filed. So I do pre-litigation as well as litigation here, pretty much all revolving around personal injury.
Okay, well, today we're just going to go over, kind of discuss the different estates and the debts and exactly what happens when either a loved one or a family member passes away. A lot of the times everyone knows that I actually handle, we've switched it to where it's PEG department, probate estate, and elder with guardianship as well. So I deal with estates a lot of the times. And one of the main questions that I always ask is that they, does my debts, am I liable for those debts? Do the debts go away? Who's responsible? So today we're just going to go ahead and kind of answer, some of those questions. Okay. You're going to ask me some questions, and I'm going to try to answer them the best of my ability. Okay. And then if you have, definitely if you have any questions or anything for us, please feel free to leave them in the comments below, and we'll definitely try to get those responses out to you pretty quickly. And then so we'll go ahead and proceed with the show.
Okay, well, I'm actually excited about this topic, and I think that I can speak for a lot of the viewers. People always wonder what happens when a situation like that happens when you have a family member that does pass away. I'm pretty sure that's a huge concern within a lot of people's minds, the debts, the estate, just all those questions. So Heather, what happens when an estate actually has debts?
The first process, of course, and before in a lot of our Facebook Lives, we address probates and estates and what you have to do, the financial responsibility, getting someone to be proved up as the executor. So basically, is hopefully you've already kind of gone through that process and we have an executor on the estate. And basically, the executor is the person, when you execute a will, majority of the wills have what's called, there's a section in there that says debts upon, payment, basically upon passing. So the executor is responsible for basically paying those debts. And I can only say how we, practice here at the, Brandy Austin Law Firm. And what we usually do is I honestly tell everybody, the male, you're already dealing with a stressful situation. So you definitely don't want the debt collectors calling you and harassing you during that time. So I literally tell everybody, gather a box, throw everything into that box, and then when I put it out of sight, out of mind, I want to ask you to come back, bring it to me, then we can kind of discuss it. But ultimately, the executor, the responsibility is to collect all the debts for the estate, and then we do the notice to creditors. And by law, and that's where a lot of people are misinformed, by law, the creditors have to file a notice with the courts. There is a legal process that has to go through. I know a lot of the times that you do, personal injury, and so the claims, it's kind of the same thing of once they settle their case and they have the reductions, that's kind of the same thing within the probate. At that point, if I have a hospital lien or hospital bills, then I try to assist as far as facilitating getting in there and doing some reductions for them. So.
Okay, so let me see if I understand. So let's say we have a situation, a grandmother and a granddaughter, and the daughter was the executor. Mm-hmm. So once the grandmother passes, the granddaughter is going to be responsible pretty much for all of her bills.
Yes, she does not carry the debt herself. That debt does not become hers, but she is responsible for facilitating either getting that debt paid off, getting it reduced, and paying it with estate funds. It does not have to come from the executor personal pocket, basically. It's from the estate. So that's another thing too that I get asked a lot of the times. If there's different estates, they don't have all this money. Estates, it can be from $500 to $5,000 million. There's different sizes, but ultimately the actual debt itself, it comes from the estate and not the executor's personal pocket.
Okay, yeah, because I think a lot of people get worried about that they're going to go broke paying off all this debt, so it's not, basically, it doesn't fall on them in that sense.
That is correct.
Comes out of their pocket.
Yeah, that is correct.
So what is the executor's duty to pay for debts incurred by the estate?
Within there, like I said, they have to actually file a claim with the courts. The notice of creditors, basically, it's a publication that gets published, stating that that person has since passed, and any debtors, creditors, anybody that they have to file that formal claim. So if they do file the claim with the courts, again, I can only attest to how we do it here. If they file that actual claim, that prompts me to contact that, usually a lot of times it's a debt collection agency, because of course administration can take some time,
Right.
Some estates can take up to a year, 2 years to settle. So a lot of them are the debt collection agencies, but whomever, the banks at that time, speaking with them, then we can kind of get in there and try to do some reductions, kind of see what the estate is. We personally strive to try to keep the family with as much money from the estate as possible.
Absolutely. Okay. Am I able to sell the property of an estate?
Yes, but not before. This is one of my biggest things. Not before you're appointed as the executor, administrator. You have to actually be appointed first, because there are some, there's some title companies will kind of get out there, get you signed in on a contract, ready to close that contract, but unless you have that fiduciary power granted by the courts, you're going to end up getting into a situation with that contract where there's a buyer of that home that is pressuring you, hey, when's the closing date? When's this? When's your court date? And as much as I like to work fast-paced, it's not always on my schedule. I am under the court supervision, so getting that, getting the court to comply with a closing date of 2 weeks when we have to hurry and do an administration within 2 weeks, it's almost impossible. So, but yes, you are able to sell the property, but you do have to be appointed first.
So it's definitely a process, just as with any other area of law. It's a process that goes, through the courts. There is levels that you have to go through, so people have to take that into consideration.
That's correct.
Do the estate debts become my own?
Yeah, we touched bases on that a little bit ago. No, they do not. And with a lot of people, they feel that it does become their own, because of course if you're, say, God forbid, if your mom passed and that was the only person that was living and you're the sole beneficiary of that estate, technically the estate is paying the debts, of your mother, so it's kind of taking away from the pot of your money, so to speak. So everybody always feels that in essence it is coming from them, but technically that money's not yours. It's from the estate, and until you do that distribution and you become, the beneficiary of that, it's not quite yours just yet. So
and of course, I'm pretty sure everybody wants to know this question: what happens if someone does not pay the debt?
Within there, a lot of the times, honestly, depending on the value of the debt, they can come back and do a lawsuit, because one, as the executor, you have these responsibilities. You have a fiduciary duty to not only fulfill the actual decedent's wishes, but again, that clause in the will, payments upon death, you are responsible to settle up the estate first. So individually, they can't come after you individually as a person, but they can come after you as either the executor, the administrator, and things of that nature. So you definitely don't want that to happen. Which there have been times, honestly, that's a bill gets misplaced, or not become aware, and we kind of go back in and facilitate things and assist with it. But just kind of being like, hey, I'm not going to pay anything at all. Yes, you can. There's legal ramifications from it.
So can they come after the executor's house, if they have a house, car?
No.
Can they come after that stuff?
Within there, and that's the difference between individually, as a person, and then as the executor. Now, say if you receive $50,000 from an estate and you go and purchase a new house with that $50,000, technically, there could be some things that could kind of come in there, but as soon as if you attempt to try, and like I said, there is something that you can do as far as to there's only so much. You kind of know the same thing with personal injury. You have that. Even if it's policy limits, you have that main number. You try to make everybody happy. But ultimately, your client, you want to make sure that they have what they're entitled to. So you can do different things. With the estate being insolvent and reductions. To where that way it can facilitate that everybody gets a little bit of something. So.
Okay. What if there is no money in the estate to cover the debts?
That's the word that I was using earlier about it being an insolvent estate, which that basically means that there's no funds. Which usually once it comes in there, because of the process of the probate, you do have to file what's called an inventory appraisement and list of claims. So usually if there's not any money within the estate and you have these debtors, literally they're going to want to see a copy of that inventory showing that, hey, there's not any assets, along with a verification from the attorney saying that. And then honestly, they'll write off the debt. They understand, if there's not, not money to cover it, there's not much you can do. So
so what, like I said, I work in personal injury, so I'm very familiar with personal injury, and we work on a lot of cases where we settle cases, and there's a settlement. And I have worked on cases before where the actual client that we're representing has actually passed away.
Yes.
In the midst of the settlement. Maybe the case has not been settled just yet and they pass away. What happens if a client who has a personal injury claim in the process passes away before a case settles?
Within there, unfortunately, and it happens a lot. Like I said, we are a general practice firm, so even though the personal injury is not my department, at some points it does become mine, because at that point, if someone passes, you do have to get the next of kin. So the biggest thing would be to, of course, I'm sure we would know who the next of kin is, but one of them would have to go ahead and kind of proceed with doing the whole probate process. And there's several different types of probates that you can do, from big to small, meaning titled, affidavit of heirship, and then of course the big independent, dependent, and then administration. But that person, the heir ultimately would have to be responsible for the estate. And then in your turn, on your side, you'd have to amend your petition and do different things to where it actually names the estate of, and then basically serve the administrator or executor of the estate to go ahead and kind of get them on notice, and then we can kind of facilitate it at that time through both of the courts, unfortunately. But at that time, it usually goes through the probate court.
So it's definitely a process.
Yes.
If a family member does not have a power of attorney on file when a family member passes, what happens?
That's a good question, and honestly one that's a big misconception. A lot of people think that, hey, I have this power of attorney and this person's passed, I still have the power to do what I need to. Unfortunately, the power of attorneys are only in effect when the person is alive. The will comes in place when someone passes. So even though that you may appoint someone, because I know even drafting my power of attorneys, the durable or statutory, one of the sections on there grants someone in the event to handle a lawsuit.
Right.
Well, again, it's only for when they're living. So upon someone passing, we would still have to revert back and kind of do the whole appoint administrator. So
that's a lot that goes into it.
Yes.
So is there a process to format a power of attorney after an individual passes, or is it too, let me see how I reword that. Is there a process to format a power of attorney after an individual passes, or is it too late?
That's the one kind of before it's too late. Again, at that point, the will comes into effect when that happens. So, and there's different things, and there's different, the power of attorney. I always state that, it's always better to have one than not have one, because, there are different things in life that happens. So, especially car accidents. Say you get in a car accident and you have this lawsuit. If you have that power of attorney that says that person can bring that claim on your behalf, and you're laid up in the hospital and you can't meet with the attorneys, this person can facilitate it. But upon passing, unfortunately, it is too late at that period.
So that brings me to another question. With you being the professional in this area, what would you say is a good, like a good time frame for someone to get a power of attorney or a will on file? Do you think everybody should have one, or what is your opinion on that?
A will, yes, 100%. I always say a lot of people think that if they don't own their home, if they don't own these different things, that they shouldn't have a will. That's not true. Anything that passes title, whether it's a vehicle, a house, I always say even if you have children, especially minor children, because there's so many different things in a will that you can present. So like a testamentary trust, to make sure that there is someone that is, a trustee if something happened to you, to take care of your kids. But as far as the power of attorney, the will, 100%, 100%. You know, I say as soon as you turn 18, get one. And then it kind of changes with you when you have, you know, through your life, when you have children, when you get married, if
Right.
you know, hit it rich and win the lottery. But for basis, like I said, a car or even a house, that's stuff that you actually want to pass title down to. The
Right.
power of attorney, I'm a little bit more, I say, jaded when it comes to a specific age, just because I do deal with the elderly department and I see a lot of fraud. I see a lot of elderly people being taken advantage of. So my number one thing before, I used to always state not to do co-agents because they would have to agree all the time. Now I always say if you have the capacity, you can execute the power of attorney for today, but make it effective upon your incapacity. And then if you have two agents, they have to work together. So
Right.
it kind of eliminates the fraud aspect of it. But
Okay.
definitely there's different things, and you know, we do provide, you know, free consultations to where each estate is different, each claim is different. So we do provide that here at the Brandy Austin Law Firm, and you definitely contact us. You can go on our website, brandyaustinlaw.com, or you can contact us at 817-841-9906. And I'm Heather, and this is Desiree, and thank you for tuning in this
Thank
Friday,
you.
and y'all have a happy weekend.
Have a great weekend.